So welcome everyone to our, I think it's 11th annual Legal Interpreting Symposium. My name is Ludmila Stern. I'm the professor in Interpreting and Translation Studies in the School of Humanities and Languages. And before we start the symposium, I would like to give the floor to the head of the School of Humanities and Languages, Professor Timothy OLeary. As I said, please keep your microphones on mute, and this event is being recorded. Over to you, Timothy.
Thank you, Ludmila, and good evening, everybody. So I'm Timothy OLeary, head of the School of Humanities and Languages, hosting this event. I want to begin by acknowledging the traditional owners of the lands on which we are this evening, at least here in the School of Humanities and Languages, on the lands of the Bedegal people, the unceded lands of the Bedegal people. And I want to pay my respects to elders past and present, and also extend that to all First Nations people who are with us here this evening. I think it's really important to make this acknowledgement, especially in the context of the themes and the content of this symposium around legal interpreting, that interpreting across cultures, and especially in the legal context of the very real impacts on people's lives of going through a justice system in which perhaps cultural diversity is not always recognized. So it's really wonderful to be able to bring those concerns together here in this symposium, and fantastic for myself as the head of the School of Humanities and Languages that this is a part of the work that we do within the school. And really great. I'm just moving my cursor now so I can see how many people are in the room right now. We have 115 participants, which is fantastic. The last time I think that I did the introduction to this symposium was in 2019, the last time there was a face-to-face one in the law faculty here at UNSW. And I don't think there were 115 people present. So of course, one of the advantages of having us online is that it's much more accessible. And the disadvantage is we don't actually get to meet each other face to face, but I think there really is an advantage, and some advantage in how we're able to do this on Zoom. But hopefully next year it'll be a face-to-face event that I'll be able to attend. So look, with that, I will hand over. So Translation Interpretation Group is within the School of Humanities and Languages, and the School of Humanities and Languages is within a fantastic new faculty, the Faculty of Arts, Design and Architecture. And our Dean, Professor Claire Ansley, is here to also to say a few words. So I'll hand over to you, Claire. Thank you.
Okay. You too. Thanks a lot. Thanks. Bye-bye. Bye.
Good evening, everybody. I would like to acknowledge that I'm joining this meeting tonight from Gadigal and Bedegal land, and I'd like to pay my respects to the elders of these unceded lands and extend that respect to any Aboriginal and Torres Strait Islanders joining this meeting tonight. I am delighted to have the opportunity to open this symposium tonight. I'd like to say welcome to the now 121 participants of this very impressive evening. And that includes all judicial officers, the legal interpreting professionals, court administrations officials, and all other stakeholders across the this meeting tonight. I would particularly like to welcome our eminent guest, Her Honour Judge Tracy Fantin, who from the District Court of Queensland. As Timothy said, this symposium is hosted by Interpreting and Translation in the School of Humanities and Languages in our brand new Faculty of Arts, Design and Architecture, or ADA, at the University of New South Wales. ADA, our new faculty, was launched at the start of this year with the vision that through creativity, collaboration and inclusion, we seek and solve problems to improve life on Earth. And the symposium tonight is definitely contributing to that rather ambitious mission that we have for our faculty. The symposium itself was founded in 2011 and is hosted annually. The important focus of this event is really to discuss practical solutions to current problems, prioritizing the role that interpreters play in courts, that link between judges and magistrates, but also court administration. And for me, this is a really important way to create that link between our university and various stakeholders, judges, magistrates, lawyers, all of you in this symposium. And it's wonderful that we have managed to keep this really valuable event going now for 11 years. The other real value of this event is that it links our postgraduate programs and our postgraduate and our PhD students to this really important professional network, and giving our students access to this professional network through life research and impact is really important and a really valuable way of contributing to overcoming and bridging those language and accessibility barriers, especially in access to justice. Just like last year, I had the honour of opening the symposium last year. This year's symposium is organised around the very impressive research that's being done in the ARC linkage funded research project, which is access to justice in interpreted proceedings, the roles of judicial officers. And that is a project led by Professor Stern, as chief investigator, and also Professor Hale and Associate Professor Stephen Doherty, and also another chief investigator, Professor Melanie Schwartz from UNSW Law and Justice. It's wonderful to have this organisation, this symposium get together today, and I'd like to just acknowledge the 8 industry partner organisations who are part of that ARC linkage research project, and many of whom are with us today. So welcome to you all. This symposium will give us an opportunity to have an update on the project's research outcomes and related findings, and it's going to be a forum where the experiences of interpreters and judicial officials can be shared and issues discussed, including significant challenges to communication and access to justice. These conversations are so important because they ultimately improve access to justice for users from linguistically diverse backgrounds. And that definitely fits into the mission of the Faculty of ADA of improving all life on Earth. So welcome to you all. It's wonderful to see now 130 people in this meeting. I don't know if that number is going to go up anymore, but welcome to you all. And I wish you all the success for this very impressive symposium. Thank you.
Thank you very much, Professor Annesley, and thank you very much, Professor OLeary, for these warm words of welcome and introduction. And I think it allows us now to start the symposium proper. As Professor Annesley has just said, this symposium builds around our ARC linkage project on judicial officers working with interpreters, implications for access to justice. But what you will hear this afternoon and early evening won't be limited to the role of judicial officers, judges, and magistrates. We are also going to look at the most recent research, as well as the role of courts in ensuring adequate working conditions for interpreters. And what we are asking you to do is, if you have questions after each presentation, could you please enter them in chat, because we are limited by time and we won't have time for Q&A after each presentation, but we will leave it until the end, and Professor Schwartz will moderate the Q&A. So I will now move to the first presentation, which I will begin in just now, and I hope you can all see the slide. Yeah, Sandra, can you? Yeah, okay. So what I would like to do now is to talk a little bit about our ARC project, about its progress, the impact of COVID on our research, and above all, share with you some of the observations that we have made during field work in the past year or so. So I don't need to tell you, many of whom are practicing court interpreters, about the importance of interpreting and its quality on the evidence and on communication in court. But a lot less is known, there is limited research on the role of interpretation users in court, namely about judicial officers, judges and magistrates, and their role in making interpreted communication effective and involving non-English speaking participants and making them what we call linguistically present. Now, it has been achieved successfully in international criminal courts, where there has been a legacy of working with interpreters in multilingual courts over many years. However, and this is ironic, there are no guidelines developed in these courts specifically for justice. And this leads to somewhat inconsistent approach to working with interpreters by judges and lawyers. In Australia, the picture is different. The document recommended national standards for working with interpreters in courts and tribunals goes back to 2017. And it's, to my knowledge, a most detailed, a most well-developed good practice document with guidelines that apply specifically to judicial officers, lawyers, interpreters, and other court participants. However, this document is not mandatory, or rather its implementation is not mandatory. And this is something I will return to during my presentation. So here is a question: how do judicial officers in Australian courts work in interpreted proceedings? From 2020 AUSIT survey, we know that interpreters provided very mixed responses about the way they experience working with judges and magistrates. Our question is therefore, how do judicial officers ensure that communication in bilingual proceedings is effective? How do they follow the guidelines developed by the recommended standards? What are the perceptions of judicial officers about their own role and responsibility for interpreted communication? And do their actions ensure that non-English speaking participants are linguistically present? And that sends us to the question of equity and access to justice. And this is the topic of our ARC linkage project, which I won't repeat. But again, I just would like to acknowledge co-investigators and the organizers of this symposium, Professor Sandra Hale, Stephen Doherty, Melanie Schwartz, my apologies for the misspelling, Mel, and Dr. Julie Lim. So we are looking at interpreting in criminal proceedings, in district, county, some Supreme Courts and magistrate courts across all Australian jurisdictions. And the cases with interpreting are mostly in migrant languages with a focus on the so-called new and emerging languages. Next year, we are focusing on cases with interpreting in First Nations languages. So to date, our fieldwork has involved 3 different approaches. The main one being probably observations of court proceedings with a focus on how judicial officers work with interpreters. And these observations have been followed up by interviews, post-observation interviews with judicial officers and with interpreters who participated in this particular case, but also involving their prior experience. And so in 2020-21, we conducted 37 observations with 17 interviews with judges and 5 with magistrates, and 19 interpreters were interviewed. And you can see a list of migrant and First Nations languages that were interpreted from and into during these proceedings. And as I said, we are interested not only in the way judicial officers work with interpreters in any languages. We particularly focus on those languages where The interpreting pool is limited, where training is limited or non-existent, and where perhaps there is no NAATI certification. Now, because of COVID, we couldn't travel interstate, and as a result, local research assistants conducted observations in courts. However, we interviewed them remotely. We interviewed judicial officers and interpreters remotely. And only one observation was possible in Victoria because of the lockdown, and our field trip to the Northern Territory had to be cancelled and postponed, and hopefully it'll take place next year. So what I'm going to discuss now are the interviews with judicial officers. Now, I understand that we haven't done a proper analysis of these interviews. And I also want to stress that these interviews provide only part of the picture. They address the perceptions that judges and magistrates have about their own responsibility of working in courts when there are interpreters. So most of those whom we have interviewed have worked extensively over many years with interpreters with a different frequency depending on where they work, the location, the jurisdiction. But everybody agreed that the number of interpreted cases has been increasing over past few years. It is important to stress, and I think it's important for interpreters to hear, that generally those judicial officers who were interviewed have a positive perception of interpreters and interpreting, and they acknowledge that interpreters play a key role in court. They have never, according to what they say, rejected or challenged a request for an interpreter. But what's interesting, the definition of the profession as they understand it is very inconsistent and I would say vague, as you can see from the quotations. And this is important because of the way interpreters are communicated with in court. So on the one hand, judicial officers generally consider interpreters to be professional who live up to their expectations. They acknowledge that the quality varies greatly and that there are many languages that don't have a pool of certified interpreters. Their praise was mixed with criticism, which usually has to do not so much with the accuracy, but with the ethics and professional conduct. And everybody commented on the improvement in interpreting quality over the past 10 or 15 years. So how do judicial officers learn about working with interpreters and ensuring that communication is effective? Most refer to past experience and common sense and to training new modules in the first year of their appointment. And interestingly enough, one half only seem to be familiar with the recommended standards. 2 or 3 acknowledge that they've never heard of the RNS. And this is also somewhat surprising considering the effort by the Judicial Council of Cultural Diversity and the authors of the recommended standards to promote over the past 4 years now the principles in these standards. Now, the perception of interpreters and their treatment can be reflected in the way that quite a few judicial officers, whereas acknowledge interpreters and mention them in court, don't necessarily greet them, and they don't quite explain clearly why they don't do it. And it is the minority that says that, yes, I have notes, and I follow these notes to introduce the interpreters and their role to the jury, and I explain that they are impartial and so forth. And so I think these mixed responses reveal the interpreter's very uncertain status in court. There is a consensus among judicial officers when it gets to their responsibility, theirs and those of court officers and perhaps court administration for providing interpreters requirements in court. Again, I know that those interpreters who are listening to us now may totally disagree and say that it is not their experience. But this is the belief of those 22 or 23 judicial officers that have been interviewed. So they talk about providing certain physical comfort to interpreters. There is, interestingly, a very mixed response about providing briefing and preparation materials. Again, some acknowledge that interpreters need to be briefed, but these judicial officers are not always confident who should be responsible for that. Others say that whenever a document is cited in court, they offer it to the interpreter. And a minority perhaps still have doubts about interpreters being briefed and shown the materials in advance, and they question their impartiality. Again, it tells us about the perception by judicial officers of the interpreting profession and a certain ignorance about the impartiality and professional ethics and conduct. Interestingly enough, nobody had anything much to say about interpreters interpreting in the dock or in other forms of close proximity to the defendant during COVID, basically not having any solutions or not having been aware of solutions such as portable equipment that allows to take an interpreter outside the dock. So how do they communicate through an interpreter? And there is a total consensus on modifying their communication strategies. They all acknowledged trying to use plain English, shorter sentences, slow down, repeat, rephrase, explain technical terms, explaining the proceedings and specialized terms. But we have to say that often this is done for the benefit of the jury and the benefit for the non-English speaking participants, rather than with having the interpreter in mind, especially the interpreter who sits in the dock. Some keep an eye on the interpreter and remember to adhere to these principles, whereas the others acknowledge that they forget that the interpreter is there because they are busy managing the case. Again, there is a much higher visibility when it gets to the interpreter on the stand, as opposed to the interpreter in the dock or in the gallery next to the defendant, who are often forgotten. Now, the judges and magistrates also see it as their responsibility to monitor other speakers, especially lawyers, who do most of the talking in court, more than judicial officers themselves. And they refer to often instructing parties to slow down, rephrase, repeat, avoid double negative, avoid, as one of the judges said, "I put it to you" type of expressions. But what's interesting also is that these actions seem to be mostly reactive rather than preemptive. In other words, they are resorted to only after an interpreter brings it to the attention of the judge that something needs to be changed in the communication. And again, I think during legal deliberations, the interpreter in the dock is forgotten. Do judicial officers interact with interpreters? Well, yes. Often ahead of the hearing or trial, they invite them to, or they report that this is what they do. Again, let's remember that we are now working with what we hear from the magistrates and judges. So they address the interpreter by offering them to speak up if they need a break, ask for a petition, clarification, and so forth. But they also interrupt the proceedings when they feel that the interpreters are not doing their job, like they sit in the dock and they don't interpret, or if their interpretation is far too brief, considering the length of the witness's utterance. A gray area is managing challenges to interpretation accuracy. And there is a diverse set of views by judicial officers about when somebody challenges the accuracy of the interpretation, a lawyer who understands the language or a family member. So some automatically assume that an interpreter has made an error. The others automatically assume that the interpreter is right. Some deflect the problem to the counsel, and only some actually try to resolve the problem, resolve an error or misunderstanding by becoming engaged in an interpreted interaction, speaking to a witness or the complainant and identifying whether there has been an error or whether it is a misunderstanding. Now, why do interpreters address judicial officers? It is mostly to seek clarification, repetition, or to ask them to the speakers to slow down. And judicial officers, according to them, welcome that. They do encourage interpreters to address them directly with these requests. And they prefer the interpreters to do that rather than somehow the proceedings continue. And an interesting quotation, that's a third, but it's a second bullet point, where one of the judges said, I think she was a good interpreter. She was quite forthright. And so if she didn't understand something, she was quite happy to interrupt proceedings and say, I need such and such. My associate commented that she was a bit bossy. And I said, no, I think that was good. That's how the system works well. I don't want someone who's a wilting violet there who will just let it go and then not ensure that the defendant understood. And I think it's a very valuable comment. But having said that, I've observed a significant gap. It's a limited action by judicial officers in checking whether the defendant or the accused really understand what goes on, can follow the proceedings, and is what we call linguistically present. So some of them said, well, I defer to the counsel. They will explain to them after the session. So just to sum up, and this was very brief, and as I said, I'm only talking about interviews. So just to sum up, these interviews with judicial officers were fascinating. They were very rich in content. They were complex. They were sometimes contradictory, but all of them were very thoughtful. And it was clear that there is goodwill by judicial officers to do the right thing. So interviews don't show the whole picture. We need to analyze observations. Most judicial officers recognize the importance of interpreting in court and trust interpreters' accuracy. However, there is no evidence that all of them treat interpreters the same as they treat other professional participants. They acknowledge that interpreters' needs have to be taken care of and met. They are happy to accommodate interpreters' requests. There is a consensus about accommodating their own speech and monitoring the way other participants speak, and they feel essentially responsible. They feel that themselves, the lawyers, the court officers, the registry are responsible for effective communication. As I already said, there is a distinct sense of higher visibility of interpreters on the witness stand compared to invisibility or low visibility of interpreters in the dock or public gallery. What really puzzled me was a very limited familiarity with recommended national standards, even by those judicial officers who said that they were familiar with it. And they all recognize that better training on working with interpreters is needed. So again, I'm repeating myself here. A real gap is a limited concern that was voiced about ensuring that non-English speaking participants are linguistically present. And whereas some judicial officers do check their comprehension and make sure that they understand the proceedings, it does not come across as something that is done by all. So what are the next steps for next year? We are going to triangulate the results of these interviews with observations and interviews with interpreters. We are going to analyze these particular interviews. Observations will begin hopefully in the Northern Territory, and they will continue in Western Australia and hopefully in South Australia as well. And the fieldwork is intended, and this is important, our fieldwork is intended to inform the analysis of a larger corpus of transcripts of court proceedings, and building this larger corpus of transcripts of court proceedings from each jurisdiction is going to happen next year. An important step is to analyze it using discourse analysis. And my colleague and co-investigator, Stephen Doherty, is about to talk about some of it in his presentation next. So thank you very much for that. As I said, any questions can be put in chat and we will address them at the end of the symposium. So Stephen, if you are ready, it's over to you.
Thanks, Ludmilla. Hi, everybody. So good to see so many new faces and familiar ones. I think that's a really good finishing point, Ludmilla, where you left off and where I'll continue because it speaks exactly to where I am next. I'll just set up the PowerPoint here. Okay. Ludmilla, can you see the slides on your end? Yeah.
Yes,
great.
perfect.
Perfect. Thank you very much. Okay. Excellent. Good. I was looking at my watch to say good morning, everybody, but it's already so late in the afternoon. So good afternoon, good evening, everybody. So good to see so many people from all over Australia and all over the world. I was looking in the chat just as Ludmilla was finishing up to see some of the greetings. I'll continue where Ludmilla left off and looking at the discourse analysis and how all of this links together in terms of the transcripts, the observations, really so that we can have a very holistic and very valid sense of the communication strategies, the barriers, and so on. So the point I'll speak to is a data set that we've been working on in the publicly available civil and criminal cases around judgments and decisions in the various jurisdictions. And I'll talk about all of these aspects because I know we have quite a mixed audience. And indeed, my background is not in law. It's very much in translation and in linguistics. So I'm coming at this and learning quite a lot as well from my perspective. So as Ludmilla had already mentioned, with the aims and the research questions of the project, we're specifically looking at the data on judgments and decisions so that we can triangulate them with the observations and the interviews and the other methods we're using in this very much a mixed methods project with the various expertise from the academics, the partner organizations, and all of the stakeholders. So with that in mind, this component of the project looks at the higher level national and jurisdiction levels, looking at trends over time, particularly before and after the recommended national standards, focusing in on communication practices, not just in the instances where there are bilingual proceedings with an interpreter, but also with respect to comparisons with monolingual, and of course, those international benchmarks that Ludmilla mentioned. From there, we can then work towards identifying specific linguistic cues and specific barriers that we can identify and hopefully work towards resolving in the future. And then again, as Ludmilla had mentioned, looking towards the international practice that's very well established, particularly around the ICC. So all in all, this is one of the several points of data that we'll use. And as Ludmilla has been mentioning, we're very much a work in progress with this data. And next year, it's something that we work with more fine-grained analyses and also triangulating everything as we go. So many of the same principles apply here. So the component of the project I'm going to talk to you now, some of you may be aware and familiar with this type of research, often called corpus linguistics. So a corpus being a body and linguistics being the linguistic element of it, so a body of data, also called text analytics, data mining, natural language processing. It comes up so much, but think of it as a kind of giant Google search of the databases that we're interested in. And this can be really useful for many reasons, both looking at these higher level trends, as I mentioned before, over time in different jurisdictions, but also looking at more fine-grained discourse analysis or content analysis or forensic analysis you may be familiar with. And this type of approach is used quite commonly in applied linguistics, in translation studies, and of course, much more recently in interpreting studies. A lot of this is happening in the EU and the international circuits as well. And the typical steps involved in such a project are to identify the data that you're interested in looking at, using formal criteria to include and exclude, and I'll talk about the ones that we're using here in the project. Gathering all of the data, processing and cleaning it, whether you're dealing with websites in our case and PDFs, and then looking at the larger scale analysis of the data, looking at, as I said, the higher level, the trends over time, the different jurisdictions and so on, before focusing in to the fine level analyses, looking at patterns and themes and specific phrases and words, as we'll get to in the coming months. And then, of course, cross-referencing and triangulating all of this to improve the validity and reliability of the findings. So this component reports on publicly available data, and I'll show lots of examples as we go through for each jurisdiction, but also in other databases like OSLI. Some of the jurisdictions have a portal through this online service. And it has been a really exciting and interesting project. It's very user-friendly. The quality of the data is very, very good compared to other projects. And the observations and interviews that Ludmilla has mentioned earlier informed our search criteria. So we were looking for specific terms, 42 at the moment, and we're adding as we go and refining. So unsurprisingly, we're looking at cases where interpreting or interpreter or interpreted, and the star indicates that it's just that part of the word, and it can occur in any other ways. And sometimes interpreters, as you know, are often called translators by others. But we also put in things like non-English speaker, and slow down, speak more slowly, loat, called, all of these terms that we know from the literature, from other aspects of professional practice, and ones that came up in the interviews and the observations that Ludmilla has mentioned. And of course, with any project of this scale, there are always these technical issues. So different databases have different coverage. Some go back all the way to 1999, some even before that. But 2010, 2011 seems like a really sweet spot for all of the jurisdictions, in that 2011 is where everything is fully digitized and available. And that's really the kind of decade of comparison that we're interested in, given that we're now coming to the end of 2021. And there are also some issues with the database itself, that some aspects aren't so reliable, that you might look up the term interpreter within a field and it doesn't show any results, but then you go into the PDF and you see that it actually is there. So there are lots of technical workarounds that we have used, using web scraper tools, for instance, to kind of take essentially a giant copy and paste of the websites into our own database to try and overcome such issues. And of course, as many of you are aware, working with PDFs and converting them into text and so on has many difficulties with it. But more or less, it's been quite a positive and interesting experience working with these databases. And here are some of the examples. You can see one here from New South Wales and the different search boxes. Again, think of Google search engine. You can select different courts and tribunals. Over here with Victoria, much the same, and so on and so forth. Some available in Word documents, PDFs. Some of the headings and keywords are already there, and they go, of course, in time and by different jurisdictions. So it's really a remarkable online resource. And of course, many people in the legal profession are probably well aware of this data set, and you may even use it quite a lot in your work. But for the purposes of our project, it's been an exciting resource to explore. And just some more examples from Queensland and the ACT. So here are some examples of what a search result would yield. So you'll see here the different cases and some data around it, judgment of, decision date, and so on. And we can click and go into each individual entry there. Something like this example you might see, and we can scroll down, and different courts, of course, and at different times in points in time have different structures and so on. So it varies, but we see typically this kind of format. You can see just some more examples of it. So we're really interested, as I said, in looking at all of the data that was available. So we've currently gotten up to just under 31,000 entries. Most of those are in the past decade, as you would expect. So the number of judgments and decisions are increasing over time, and you would expect them similar, I guess, to the population in each jurisdiction. We see New South Wales out here on top, and Victoria, Queensland, and so on, and the increase and decrease at different points in time. And of course, the data is incomplete for 2021. Often the entries are uploaded, all at once, a month or 6 months afterwards. Some of them are updated on a more regular basis, which has been interesting, and you can see that in the logs. But just to show a trend over time, looking at the increasing number of cases and their distribution in the different jurisdictions. And what's also interesting, and again, if you are in the legal profession, will know that this may not be surprising, but just the distribution of the civil to criminal cases, obviously civil much more of those chunk of the total. So the civil here in the yellow, the criminal in the kind of pink, and the totals in blue, just to spread it out in terms of time, jurisdiction, and the types of cases that we see. Unsurprisingly then, when we use our search criteria, so here's just a screenshot of when we look for interpret with that gap to be interpreting, interpreted, interpreter, and so on. We have just over 6,000 entries that return, and then we have to manually check, and we see these increasing over time as well. And not just increasing over time, but increasing in relative terms to the overall number. And so becoming more prevalent, or at least more explicitly referenced in the data. So as Ludmilla had mentioned already, we're analyzing the data as we go through and collating everything and triangulating as we go. But so far we can see year-on-year increases relative to the total in the jurisdictions and also nationally. And many of them, unsurprisingly, about 62% of what we've analyzed so far, only refer to the interpreter in one instance and don't really go into any detail about it. So here are a couple of examples here. So saying someone was self-represented with an interpreter or came in person with the interpreter, and there's no other mention to it, and so on. But many other cases, and these are the ones that are really, really interesting, go into quite a lot of detail and report on some experiences, positive and negative, and really relate to a lot of what Ludmilla has been speaking to already. And we've essentially tried to categorize these into the themes as they've been emerging, noting that we've gotten through the New South Wales, Victoria, and South Australian data so far. And these themes are around these 6 aspects, right as we see it. And we'll refine them, I think, as we go next year, essentially relating to the assessment of an individual, of evidence, procedural issues, access to justice more broadly, professional aspects, and then, of course, as we're interested in the national standards, references to the RNS. So I'll just go through and highlight some examples to show the types of references that we're bringing up as we go through these themes and all of these data. So some of them relate to, as I said, the assessment of individuals. You're talking about someone giving evidence through an interpreter who may not have caught the fine shades of meaning and may have conferred on what the appellant said, an impression which he had not meant to convey. So it's really interesting to see these nuances and the barriers, I guess, in a way around JOs are experiencing towards assessment of individuals in these examples, for instance. Further to the point of assessment of individuals, there are also mentions around the need for an interpreter, not needing the interpreter in early occasions, not talking about language difficulties, going through proceedings without an interpreter. No interpreter has ever been present at any medical examinations in this case, and so on. So you can see it forming an aspect of the judgment or the process in terms of the need for an interpreter or not, and making that judgment and looking at evidence before and how that relates. So it's really quite interesting to see this from a linguistic perspective as well. And we see that also becoming a barrier in terms of assessment of evidence. Even some statements like there will be no practical means for the court to assess the demeanor and credibility of the witness if their evidence were given through an interpreter and via audio link. This manner of giving evidence is far too remote to be of any assistance to the court. And also, as many of you would be unsurprised by, in the last couple of years, a lot of references to remote interpreting, audiovisual link or AVL, and the associated difficulties with those, which we'll explore as we go through the data. So essentially, difficulties and barriers in assessment of evidence due to these issues. Further in the idea of assessment of evidence, talking about competence, insufficient evidence that the interpreter was not accurately translating what was conveyed, difficulties with interpretation. I was worried that if my exact words were not what was interpreted, and so on. So it's really interesting, and there are many of these. I'm just picking out the most relevant examples in each category. And it's really interesting to see the reflections of the JOs and the discussions that they're sort of having in this process, in the data that comes out in this analysis. There are also procedural issues in terms of what, for instance, here may constitute a denial of procedural fairness. No knowledge of codes of practice around being interviewed with the police and English and so on. Some really interesting cases here that go into quite a lot of detail on the importance of having a qualified interpreter and the issues that raises later on, for instance, with police interviews and the process and procedural fairness therein. And then more broadly, as I mentioned, access to justice more as a recurring theme over and over again. So talking about wanting, in this case, proceedings to go ahead without an interpreter and being asked, no, should we stop and make sure that we have access to an interpreter and proceeding anyway, and so on, and that being used to seek adjournments. And so on, and then later on resulting in a denial of natural justice and so on. So these things are really, really interesting. They really show that at all aspects, there are issues coming up for all of the stakeholders, and more on the access to justice. Also interesting aspects around, for instance, here, an accused saying that they didn't actually require an interpreter, or they were deemed to not require an interpreter. And it was quite interesting, for instance, here in the final statement about cautioning, but the person in question the court couldn't be sure that they had actually understood that, and so on. And this really interesting theme of it being used for and against, in many cases, access to an interpreter or not, needing it or not, and some really interesting arguments unraveling that are really have been interesting, as I said, to explore, but also relating to professional practice as well. For instance, not knowing around confidentiality and assuming an interpreter would have a conflict of interest because they were in that same language community, and also even some troubling situations, for instance, about someone becoming aggressive and abusive towards the interpreter. So really interesting professional aspects to it as well. And then, of course, this is more recent with the recommended national standards, but references to, for instance, statements around having to use a NATI accredited interpreter, that bilingual solicitors should not be the interpreter, and so on. So we can really see a lot of these, particularly in the last few years, and these more explicit references. So naturally, this is a work in progress, and the sample that we have, albeit 30,000 cases, really only include the cases that are available in that database, in those databases for each of the jurisdictions and in OSLE. This is a work in progress, as I said, and we'll be adding to it as we go. And also adding to the search criteria if we need to refine it, because obviously there are going to be many cases in the database in which there has been an interpreter, but it's not explicitly mentioned in the judgment or the decision, right? So in a way, this is a sampling bias in the sample that we currently have, because we're really only seeing the cases in which it's noteworthy or mentioned in some way, or it causes an issue, right? So probably getting some more false positives. And it will be interesting then, and this is something that we'll do with triangulating the data later on, to look at records for judgments and decisions where we know there was an interpreter, but there's nothing in the actual documentation making reference to that, i.e. it went well, one could assume. So as I said, the data keeps getting uploaded. 2021 will be completed in the next couple of months, and that will give us some more data, especially when we get into the end of 2022, to compare before and after the implementation of the recommended national standards. And then with this cross-referencing that we can look at, for instance, we have access to records, which is difficult to pinpoint, but we will be able to at some point identify and cross-reference instances where we know that there were interpreters for those cases, but again, there's nothing mentioned in the decision or the judgment. So that will be really interesting to look at, and will also balance the sampling quite a lot. Obviously, there's a lot more of the fine level analysis to speak to. We've got little time today to go into specific detail, but just to give you a taste of the richness of the data that's available in these resources. And I think it will be really interesting to look at specific outcomes as well as sentencing, and for instance, the number of appearances and the duration of time as well, and in terms of looking at it from all of the different stakeholder perspectives. And of course, then we'll eventually get down to focusing on specific linguistic and communication strategies, what works well, what seems to cause issues, and these general barriers. At some point also, probably this time next year, and hopefully in time for the next symposium, we'll be able to compare, of course, the different courts, the jurisdictions, and indeed the language groups that are of interest to us in the project, and perhaps also looking at the comparison with similar data available through the ICC, the International Criminal Court. So that's it from me, and just a snippet of this really exciting data that's available and that we're hoping to explore in more detail as we go forward with the project. Thanks, everybody.
Thank you, Stephen. And it was absolutely fascinating, and the detail and the sophistication of your analysis. And we do look forward to working with these decisions and transcripts. And as you just said, hopefully we'll be able to bring at least some of it to next year's symposium. So thank you again. I'm about to invite Judge Tracy Fenton of the District Court of Queensland to have a brief conversation with me rather than an interview. And I just wonder, Tracy, if you are there. I saw you among the participants. Perhaps you could unmute yourself. And while this is happening, I wanted to acknowledge that this project that we are conducting, that we owe not only to the university and the Australian Research Council for supporting us, but also for as many as 8 partner organizations from the industry, without whom it would have been extremely difficult to conduct this project. And they include OSIT, AIJA, JCCD, Multicultural New South Wales, NAATI, Aboriginal Interpreter Service of Northern Territory, TIS National, and all graduates. So their financial, in-kind, and other support and their expertise have been a great support to us. But in addition to that, I also have to say that our project and our fieldwork has been supported by those who are not officially on our list of parties, and they are chief judges and chief magistrates of all jurisdictions. And I would like to, and not only them, but other judiciary who have supported us in this project, because without their support, it would have been extremely difficult to gain access to courts, especially in these days of COVID, and also get support to interview judges and magistrates. And so I could see among the participants Justice Helen Wood, and Chief Judge of Queensland, Judge Brian Devereux. And I would like to thank you in particular. Chief Judge Devereux is the one who put me in touch with Judge Fantin, whom I hope to interview now. Are you there, Tracy?
It's Brian Devereux talking. Can you hear me, Ludmilla?
Yes, I can hear and I can see you.
Oh, I've just sent a text to Tracy and she told me that she's having trouble with the Wi-Fi. She's just lost connection and she's trying to reconnect.
Okay, because I saw, thank you very much. I saw Judge Fantin among the participants, yes. And so hopefully she will be able to join us.
Well, he's in Cairns, of course, and trying to get back on with you.
Okay. Well, I'm just wondering whether.
Here I am.
Oh, great.
Here I am.
Great. Yes, thank you. Thank you,
Sorry
Judge Fantin.
I just, as we were about to start, lost internet connection on the court's Wi-Fi.
Oh, God.
Hopefully.
Yeah, not a good thing when we all work remotely. So Judge Fantin, thank you very much for joining us today under these circumstances. And as you will remember, I interviewed you earlier this year, and I was incredibly impressed by your approach to working with interpreters. In fact, we ended up having 2 consecutive interviews because there was so much to discuss. And I would like to just raise only some of these questions. We have just under 20 minutes, and let's see how we go. So first of all, could you please tell us briefly how often you work with interpreters? What are the main languages common in Cairns or when you are on the circuit?
There has been a significant increase in the number of interpreter matters in the District Court where I'm based in Cairns. I also circuit to Brisbane and other regional centres in Brisbane, but I'll focus on Cairns. We deal with matters requiring First Nations interpreters, and the most common First Nation languages are Wik-Munkin from the northern part of Cape York, and Torres Strait languages, but most commonly Torres Strait Creole. There are other Indigenous languages less often, Gugu-Yimithirr from the Hopevale area. And otherwise, Cairns is quite a culturally diverse place, so it's quite common to have interpreters in a multitude of languages. Just off the top of my head, most recently Hmong, because there is probably the largest community of Hmong people in Australia here, African languages, French, Chinese, Mandarin, etc. So quite a range.
And are you aware of the different competence of interpreters who come to your court? Does this become immediately apparent to you?
It is, and I am aware of it by the time of the application, because the affidavit, if it doesn't, will be required to identify the interpreter's qualifications and experience. One of the issues regionally is that there is a real lack of adequately accredited interpreters in the sorts of languages I'm referring to. So we are often working with interpreters who may have court experience but don't have the kind of NAATI accreditation that would otherwise be desirable. And they have in separate discussions, raised the fact that they would like to be able to be supported to obtain accreditation and haven't been able to do so yet for a variety of reasons.
Thank you. So I'll come back to this topic in a minute, but first I would like to say that when I spoke to you earlier, I was very much impressed by the depth of your familiarity with the recommended standards and how every single answer you gave me in those interviews clearly were based on your understanding and adherence to the recommended national standards. So do you personally find it challenging to follow the recommended standards? And the reason clearly I'm asking this question is in response to so many other judges not being familiar with it. Sorry, I know that there's more than one question in this question.
The answer to the first question is no. I don't find it challenging at all to follow them. I don't think there's anything in them that's inherently difficult. I was appointed relatively recently, so I'm only 4 years on the bench. In late 2017, I had a lot of experience as a practitioner working with people for whom English was not their first or second language. But I didn't receive any formal judicial orientation until late 2018. All judicial officers in Australia tend to do that course, but often not until they've been on the bench for up to a year. That course does include, from memory, some really good training for working with interpreters in court, but it may be the only formal training that judicial officers receive then for years. And that's a real issue. I think there's a compelling need for regular training for judicial officers. But I became aware of the recommended national standards when they were first promulgated, because a judge on our Supreme Court is on the Judicial Council on Cultural Diversity, and she circulated them to all of the judges of the district and Supreme Courts in Queensland. So that is how I first became aware of them, and I printed off all of the relevant fact sheets, and not long after that, Queensland, of course, adopted its own guideline for working with interpreters in Queensland courts and tribunals, which largely reflected, but not entirely, the standards. So I then just adopted a practice of using them in every single case and developed my own checklists for what I needed to ask and do at every step of the process. I think they're easy to use and they're excellent.
Thank you. And in that case, and I understand that you may not be able to answer for your colleagues in your and other jurisdictions. So how can you explain the reason why so many other judges are not familiar with the standards that have been promoted so widely? In fact, why is there almost an implicit reluctance, if I may call it this, to follow any other guidelines or, guidelines in those bench books that have some comments about how to work with interpreters?
I think well, I can't speak for others, but I suspect it's a lack of ongoing judicial education about it. So we were notified of the standards when they came out, but of course we receive hundreds of emails every week about a variety of things. And frankly, it's a struggle to stay on top of all of the legal content we need to be able to continue to do the job properly. So it may just be a time constraint. And I think that unless there is a structured process for educating judicial officers to improve their working with court interpreters, you're going to be left with a situation where you might find ad hoc improvement, but it needs to be structured judicial education, for example, by incorporating a session in an annual judges' conference, which in Queensland is something we were going to do until, of course, the conferences were cancelled in the last 2 years due to COVID. So I think those issues could be addressed by judicial education on a regular basis rather than just a one-off when you start. And in Queensland as well, there has been an update to our bench book direction to a jury when your trial involves interpreters. So as people become more familiar with that, and I'm sure all judges who are working in a jury trial with interpreters would turn to that and use it as a resource, but that's really at the back end of the process. That's what you tell the jury about, apart from an introduction to them of who the interpreter is at the start and what their role is and their obligations.
Do you think there are significant risks of not applying recommended standards or acknowledging the interpreter's requirements? Do you think that there is a risk for the outcome of an interpreted case for equity, access to justice, or even the very process that takes place in a courtroom?
Yes, I think that almost goes without saying. I think the standards have resulted, and their adoption in the guidelines that we have must have improved the standard of the process, both in terms of the experience for the court interpreter, which may have been less than ideal in some matters, but also, most importantly, for access to justice for the person who is receiving the benefit of the interpreter. I think it's critical. And the more judicial officers can be informed about it, to be able to facilitate a process that produces the best evidence, the better off everyone will be in the process.
I asked you earlier on about working with interpreters that have a wide range, very different level of competence from the ones who are either trained or have credentials at a high level on the one end of the spectrum, and on the other, perhaps interpreters in the new and emerging languages, or interpreters in First Nations languages, where and I think I'm talking about in broader terms, I'm talking about interpreters in languages where there is limited opportunity for training. So do you feel that it is your responsibility as a judge to communicate differently, or to offset the fact that interpreting competence might be lacking in some instances? Can you do more, in other words?
Personally, I do feel a responsibility because everything that happens in the court is, in effect, the judicial officer's responsibility. So yes, if I know the interpreter might have practical experience but not accreditation and not have the same kind of formal training, I will take extra care to be more explicit, to confirm their obligations under the Code of Conduct and what I expect of them, and in particular to confirm that everything must be interpreted, not just occasional sentences. And there's often a tension over that issue because sometimes you will have a submission made by defence counsel, if the interpreter's for the defendant, that the interpreter doesn't need to interpret everything because the defendant has competence in English but just wants to have the assistance of the interpreter as and when required. That can be quite dangerous for a whole variety of reasons beyond this presentation. So it's even more important in a case where the person isn't as extensively trained or accredited to have that discussion at the outset. What's the expectation? You will interpret everything. these are your obligations. You're not to have private conversations. If you need a break, you have everything you need, etc. But it's also more important in a case like that to explicitly check for conflicts or any difficulties that might arise from the nature of the content, particularly, for example, in sexual offence cases. And it's preferable that those things are sorted out before the day of the hearing when the interpreter's present, but sometimes that can't always happen. So, for example, any difficulties with conflicts because of knowledge of family members, if it's an emerging language or there's a very small cohort of speakers, and any sensitivities with respect to the gender of the interpreter and the content of the charges, those sorts of issues. So I'll take more care with someone who's not accredited to spell all of those things out, but particularly their ethical obligations.
I was going to ask you about cross-linguistic challenges and maybe some cultural challenges, because clearly you are aware that many languages, most languages, don't necessarily have equivalents to legal and other terms, and there might be some other cross-cultural challenges to interpreted communication. Would you be able to comment on that?
I include that question really in my checklist of matters I ask the interpreter about before we start, that if they consider there is a potential for a cross-cultural miscommunication or something of that kind, that I really want them to take the initiative and raise that. And of course, those matters are not uncommon. So from my point of view, I really appreciate it when the interpreter is proactive and does raise their hand and say, there's a potential miscommunication here, that word translates in this way, and this is the difficulty with it. So it's critical, I think, for the interpreter to be proactive about those matters, but I always flag them at the outset as well. And it has been not uncommon, particularly in languages spoken by fewer people or languages that have a much smaller vocabulary than English, for the interpreter to say, look, there's simply no direct translation of that expression or that word. They'll have to ask it in a different way, or I don't understand what they mean by that.
As I said in my presentation earlier, many judiciary whom I interviewed said that they don't necessarily check whether the defendant or the accused or even a witness or a complainant understands what's happening, and they leave this responsibility to their counsel, that is, if they are represented. What are your thoughts about it? Do you have any ways of ascertaining that your non-English speaking participant actually gets the benefit of understanding what goes on?
At what stage are you referring?
Throughout, I think throughout the proceedings, and also at the end of a trial, at the end of sentencing. But I think as the trial goes on.
And this is assuming we have a trial with an interpreter.
That's right. Oh yes, only about the within the interpreter.
I think that I would ordinarily ask at the start, once we commence and the interpreter's sworn and been asked questions, etc. But it is fair to say that I certainly would rely upon counsel for the defendant, and I suspect most judicial officers would then rely upon counsel for the defendant to raise any concerns once we're underway about the defendant not understanding something, because if you're satisfied that the interpreting is working as it should, then there would be no reason to continue to check in about that. At the end of a sentence, it's slightly different. I might ask the defendant whether they had understood that, and if not, then go back and explain it again through the interpreter. But it's not the case that I would frequently check in with a defendant to check that they are understanding everything, because there are two people on their team who should be alerting the court to any difficulty.
And probably the last question is, could you tell us how you conduct the sentencing when an interpreter is present? What do you do when there is an interpreter? And I don't want to ask leading questions, so.
I would always give the interpreter the documents that are going to be referred to, and preferably in advance, if that's possible. So when the defendant is arraigned, the interpreter would always be given a copy of the indictment so they can read along with it and refer to it. If there are any documents of any complexity, for example, schedule of facts or other documents that are going to be referred to on sentence, it's my practice to give the interpreter all the documents to assist them as much as possible to follow the evidence. Sentencing in Queensland, which occurs differently in other states, is usually done on an extempore basis. So it's often almost exclusively done as an oral decision delivered. So the interpreter will not have the benefit of the judge's sentencing remarks to follow. So that makes their job much harder. And it means that there's a need to go much more slowly and to simplify the sentencing remarks. It would be different in New South Wales and Victoria, where most sentencing remarks are reserved and delivered as a written judgment, and the interpreter can have the benefit of that document in writing.
And of course, very few judges follow your pattern of behavior, and very few interpreters actually get the judge's note or draft when the sentencing begins. So thank you very much for your time and for this very generous interview, for sharing your experience. I heard from some of the judges who work with you that you have been an inspiration in promoting recommended national standards. And yes, I think if our audience could unmute themselves, they would have all applauded you very loudly. So thank you very much, Tracy, and looking forward to more judges following in your footsteps.
Thank you very much, Ludmilla, or Professor Stern.
Ludmilla.
One other thing I wanted to mention was, which I've noticed could be, it's going to be an emerging issue in Queensland, is the interaction between court-appointed interpreters and the intermediary scheme. So Queensland has only commenced this year a scheme of intermediaries, or in other jurisdictions they're called language assistants or communication assistants for vulnerable witnesses. Of course, that's been happening in other states and New Zealand and the UK for some years. But one thing I have noticed is that, and Cairns is a pilot as well as Brisbane, we are getting an increasing number of those applications which now incorporate an interpreter as part of the proceeding with the intermediary. So at the pre-recording of the witness, there is the intermediary present to assist with language difficulties, but also an interpreter, and sometimes also an emotional support person. So it increases the number of moving parts exponentially.
Yeah. Well,
that
thank
would
you.
be an interesting area,
Yeah.
I think, to have a look at in future.
That would be great. And thank you very much for this edition. And I can see lots of very appreciative feedback coming through in chats.
Well, I'm very grateful to have the opportunity to talk about it. As you know, I have a real interest in it. So thank you very much, Ludmilla. It's a pleasure to talk to you.
And thank you. Thank you. Okay, and now we are moving to our next presentation, which is by Rima Naja, the manager of the panel and industry development of Multicultural New South Wales and our ARC industry partner. So Rima is going to talk about briefing and background information for court interpreters. So Rima, I'm just about to allow you to share your PowerPoint. You should be able to do that.
Thank you, Ludmilla. Good evening, everyone, and thank you to the University of New South Wales for allowing me to be part of this evening's event. Okay, I'll just share my screen. Yes, I think we can see that. Yes, okay. Right. So my presentation will look at, obviously, from a service provider perspective, how we brief or we don't brief an interpreter. And the challenges, the benefits, and how do we move forward by implementing some of the key standards or key fundamental requirements for interpreters to be able to work better in a legal setting. So first of all, I'd just like to, for some of the practitioners that are with us today who don't know about Multicultural New South Wales, we're a government language service provider, and our overarching priority or focus is about promoting the state sustainability and standards of the industry, but more so in terms of the language service, being a language service provider, and my role is to try and strive to implement best practices for interpreters and translators in the industry in collaboration with key industry partners. And the focus here today is about getting briefing and background material to interpreters in a timely manner, but also at the appropriate times. I'd like to state up front that it has been a challenge as a service provider. It has been very challenging over the last couple of years to start to move the different key stakeholders and the bodies into or shifting their behaviours and some of the culture. And there is, a long way to go with that, but we have made, I believe with Multicultural New South Wales, have made small steps, but we need to continue with making some of those changes in the next, couple of years. Briefing is a burning issue. It's an ongoing issue for us as a service provider, but also for the interpreter. And we can all agree here today that it is a fundamental requirement for the interpreter for them to be able to undertake their work at the highest quality. What I'd like to move into is just to look at the different perspectives or assumptions that the different key stakeholders make about briefing and background material. So from the registrar and judicial officers, what we hear, what our team usually hears is that, the interpreter only needs to interpret what is being said at that time. I can't pass on any kind of confidential information. So as a language service provider, we're very aware that at times, we know that a lot of confidential and highly sensitive information is being exchanged, and at times we can only have it at certain points. And again, that is one of the challenges with working with courts and the judicial officers. It's not the role of the interpreter to have access to information prior to the matter. So a lot of some of the registrars also have, they worry about, asking and for exchanging information with us. They think it is of highly confidential nature. And should we be having access to it, even as a service provider, and the interpreter. I can't give you a brief of the case or the matter. It's confidential, or we haven't got time for that. So they're some of the key statements that we hear, and we have to sort of manage on a daily basis. In terms of from a service provider perspective, so, you know, we are actively following up on seeking out background information or requesting that briefing occur for the interpreter. So we are dealing with the different key stakeholders or the officers on their behalf. You know, and we're always telling the interpreter, look, we're waiting to hear back from the courts, what they say, what their decision is. And I can understand that's frustrating from our end, but also frustrating for the interpreter. So for some interpreters, we may not even get anything. We may not even get a response, or we may come across very good officers and who provide us with the information, which we then can provide to the interpreter. We need a process in place. So that's definitely what we, you know, keep talking about with New South Wales courts and other key stakeholders. And the big one from our end is that definitely courts need to be trained, again, in understanding the standards and applying those standards. From the interpreter's perspective, and I'm sure you can all, you're probably all nodding your heads when you see some of these. So from the interpreters, I can hear them saying, I need this material to prepare. It makes a big difference. Yes, it does make a big difference, and we totally agree and support that. I'm an officer of the court too, and this is where the courts need to acknowledge, I mean, and some courts do it better than others, or where the interpreter is an officer of the court. Why do I have to ask for a briefing or background material? So that should be automatically given or provided to either to the service provider or to the interpreter. Why do I have to argue with the officer all the time to get information to do my job? They still don't understand our role as interpreters. So again, that's a common theme that we see among other services and key stakeholders, where they, you know, where education and training is required in terms of understanding the role of the interpreter and being able to working with interpreters better. There's not enough information provided at the booking request stage. We need some information or briefing to know what to expect on the day. And this has been happening for many years, and it needs to change. And I hear that a lot, and it is unfortunate that our, you know, even some of our practitioners and practitioners around other states where it hasn't been working so well, and there is a need for change. And one of my focus areas, like I said, is to be able to start to facilitate some of that change and get some of those requirements for the interpreters to be able to do their job. When I know what I'm going into, then nothing surprises me, and I get on with interpreting to the best of my ability. All right. So in terms of the context, and this won't be, this is not new to you at all, and I think I found it beneficial to revisit some of these reference documents, some of the research, just by way of review, and really about reinforcing the need for briefing, and which we all agree on. So there have been obviously a number of sources that have discussed, initiated, and referenced the value of briefing interpreters in the legal context or the judicial process. And one of the primary documents or reference documents is the recommended national standards for working with interpreters in courts and tribunals, to what we're speaking about today. So in particular, standard 17, 24 and 26 really highlight the need for briefing, but more specifically standard 24. If I could just read out a part of that. So the legal representatives for a party should ensure that interpreters whether or not engaged by those legal representatives are appropriately briefed on the nature of the case prior to the commencement of proceedings. The interpreter should be provided with all relevant materials, including those that the interpreter will need to either sight translate or interpret, subject to Standard 26. The interpreter should be afforded a reasonable amount of time to familiarise themselves with materials that are relevant for the process of interpretation in the particular case. So, yes, so it's a standard that we need to apply better in as a service provider, but also in the court context. So we also have the court bench book and the handbook for judicial officers, which came out just recently. Again, it references the need for briefing interpreters. So we're starting to see a lot of reference documents that say, yes, we need to brief the interpreters, but we're not actually doing it in a consistent and in a consistent way. And how do we then start to do that in a consistent way as a service provider? And we'll come to that shortly. We know that the psychological benefits of getting a briefing. So the more you are prepared or exposed to, sensitive or traumatic material, the better prepared you are and better able to manage those interactions or situations. And as noted in Judy Sava's resilience presentation. Okay, so in terms of the research, again, this will not be new to you, but if interpreters are briefed, we know that it improves the interpreting performance, accuracy when information is given to them prior to the matter being heard. And I hear that from our interpreters. So our interpreters who are afforded a briefing or background material do say that, the court process went very smoothly. Their performance was, better in terms of accuracy. We've got feedback from judges and magistrates that it was, that they saw the benefits, I suppose, when that occurred. So when interpreters need background information, it's about learning about the context, the subject matter in order to better comprehend the case and to learn the specialized terminology. And this is referenced from helping interpreters to truly and faithfully interpret evidence, the importance of briefing and preparation materials. It's an article by Professor Sandra Hale. Another article also talks about the importance of collaboration and teamwork with the interpreter in the court process. So they should be seen as an integral part of the judicial team. They shouldn't be singled out. And the other key sort of research that tells us that interpreters should be offered a briefing to prepare for those emotional complexities. So again, just getting interpreters prepared for those more difficult or complex matters. All right, so in terms of Multicultural New South Wales as a language service provider, we've also gone through a process where we've listened to our interpreters in different forums. We've had focus groups, and we've also we've had a survey done early in the year, where the biggest issue again that came out for interpreters is the lack of briefing and access to background material. So as a language service provider, how do we sort of move that forward? How do we implement this? So we are proposing a strategy to formalise a process where briefing of interpreters is built in both into the booking and the practice process. So we're having a dialogue with New South Wales courts to I suppose, formalise a process, put a process in place where some baseline material can be provided to interpreters at certain points. and also looking at our own booking practice. So at what point can the booking officer provide us or provide the interpreter with any material to be able to prepare. The other focus for our agency is looking at the immediate and long-term benefits of the effective briefing and supplying background material. So just very quickly look at the benefits to all those three key stakeholders. Again, it will not be a surprise to you, but what we know as from a service provider perspective, and if you were a service provider with us, you'd know that the benefit from briefing an interpreter allows for more efficient allocation of interpreters in the first instance, including matching experience with need. So what we're talking about there is that where there's a very high complex and sensitive case, sometimes we may seek out the more highly experienced interpreter to be able to manage that case or that matter. It also allows us for the assessment of additional requirements that may add value to the use of interpreters in that matter. So we may equip them with simultaneous interpreting equipment, which we have been doing more recently, and also access to additional information. The provision of support pre and post assignment to the interpreter, which will minimise the impact of potential vicarious trauma. So where we may have access to information also, but may not be able to disseminate it at all, but we have access to some information, we can verbally report that to the interpreter. So providing any information or support to the interpreter to be, to minimise that impact, that's where we try and intervene and work with the interpreter, so there's no impact there. In terms of courts, how will they benefit? And I must say, honestly, some courts, some of the New South Wales courts vary in terms of how they view briefing and providing background material. But what I need to get across to the New South Wales courts is that it'll be more efficient and they'll be ready. Our interpreters will be prepared in terms of interpreting and the court process. It increases the confidence of the judicial officer in the allocated interpreter and in their preparedness for the assignment, knowing they've been briefed. It also minimises the need for continuous clarification by and for interpreters in the court process. And lastly, given interpreters are deemed officers of the court, the information is not a risk. So I think that's a very important point there for the courts. How will interpreters benefit from briefing? So again, they'll have the ability to prepare for the different scenarios or interaction that they'll have, awareness of what they may be faced with. It also will minimise the impact of possible stress or trauma from exposure to those traumatic narratives or sensitive material. It enhances the capability and efficiencies in interpreting, and it positions the interpreter as an equal profession in the court process. And again, it's a big education piece on our part with New South Wales courts. Now, some do it better than others, as I've said, but that continuous education is required. So what might it look like? So how can we implement this, as practitioners, but more so as a service provider? What I'd like to see is an operational process that is based on the JCCD recommendations or the standards, which is agreed by all parties. And if I can enact or implement some minimum standards to start the conversation and ensure that something is afforded to the interpreters, then we've made some progress. So we want courts to agree to provide minimum background material, so a fact sheet, or a witness statement, or even a short description of the case. And we need to decide on what point and what material can be provided. So at the time of the confirmation of the booking versus at the time of court. So we acknowledge that, that again, given the sensitivity and the confidentiality of some of the material, some of it can only be provided at the time of the assignment when they arrive on court, and some of it may be able to be provided prior to the, the assignment. So there are processes that need to be further discussed with New South Wales courts. Secondly, to decide what information can be made at the booking confirmation, like I said. Thirdly, the interpreter to be given the time to go through material if given on-site, or to be given on-site, or be verbally, or given a verbal briefing. And finally, responsibility of the solicitor, prosecutor, or Crown to brief the interpreter on arrival. And I think that is one of the key, I suppose, operational requirements that we would like to see, that they take some responsibility for briefing the interpreter. So there's some of the key, I suppose, actions that we'd like to take forward with New South Wales courts to try and implement one of the key standards for our interpreters and for the industry as a whole. So, and I'd like to hear in the chat if anybody, if anyone has any suggestions or feedback as to how we might do it. Yeah, if you've got any other ideas or ways of doing it, I'd love to hear from you. All right, that's it from me. Thank you.
Thank you, Rima. This is fascinating, and congratulations on your excellent work. I think if you continue at this rate, the interpreters will benefit tremendously, and they won't have to adopt any forms of guerrilla actions by trying to approach lawyers on the side and so forth and try to get some preparation materials. So really, really well done. Now, our next speaker is Professor Sandra Hale, a co-investigator in this project and the founder of this seminar when she came to the University of New South Wales. So Sandra, over to you.
Thank you, Ludmila. Thank you, everybody.
I think I think you need to click something else on your...
showing the wrong screen?
Yeah, that's right.
Hang on, because I'm on 2 screens.
Uh-huh.
Hang on, let me try again.
And while Sandra is working on her PowerPoint, you might all be aware that we are slightly running out of time. So if you need to leave, go ahead. We'll probably have to cut down on the Q&A, but we'll see what we can do.
How about now? Can you see?
Okay.
What can you see?
Look, I think we can work with it. It shows more than one slide. It shows
hang on. No?
No, still Stephen, you might
nothing there.
Oh yes, perfect.
Yeah.
Perfect.
Okay.
No. Yep.
All right. Sorry about that. It
okay.
plays up with the 2 screens sometimes. So thank you, everybody. I'm joining from Guringai land, so I'd like to acknowledge the traditional owners of this land. We are running out of time, so I will do this quicker than I would like to. So what I'm going to be doing is to give a brief overview of research into interpreter performance in the last 10 years from 2011 to 2021, which I've conducted with colleagues. And I'm talking now about the experimental research. And for those of you who may not know the difference between descriptive and experimental research. So my initial research before that that, 20 years ago and so on. And most of the court interpreting, legal interpreting research, you know, in the prior years before the last 10 years have been mostly discourse analytical, descriptive, exploratory research studies to explore the issues, to describe what was going on, to see what issues they were when with interpreters, how interpreters worked, and so on and so forth. And so to identify the issues. And then we moved on to experimental research once those issues have been identified to test hypotheses. So to, instead of just explore and describe, to move on to the effects. So to show through experimental research, which is controlled, what each of these issues actually mean to, in this case, to interpreter performance. So that's the importance of having experimental research, because we move from the description of anecdotes and so on to what actually happens. So what are the effects of different aspects? So the main issues that have been identified with interpreter performance have been interpreter competence and availability, and that's something that we talked about today. So what is the difference between qualified and unqualified interpreters, trained and untrained interpreters? And this seems a little bit obvious to people who are outside of the interpreting industry or profession, but within the interpreting profession, it has not been obvious. There has been quite a lot of debate and you know, quite a lot of, yeah, I suppose, debate about the need for training and education in interpreting. So that's one of the major issues. The next issue is the difference that the location of the interpreter makes. So whether face-to-face interpreting is better or worse than remote interpreting, and that's become even more important now after COVID. And the second aspect that affects or can impact on the performance of the interpreter is what we've been talking about just now. So the working conditions that interpreters work under. So under working conditions, we have briefing, which is something that we've been discussing just now, the mode of interpreting that's being used, whether it's consecutive or simultaneous, and the equipment and the working space given to the interpreter. So for the first question, do interpreter qualifications or training make a difference? So I'm not going to go into detail with all of this research, but you can read on the right-hand side there is an article that we published with my colleagues, was published in 2018, Interpreter Performance in Police Interviews, Differences Between Trained Professional Interpreters and Untrained Bilinguals. And we analysed the performance of 100 Spanish-English interpreters and bilinguals in police interviews in a simulated police interview. So the interpreters were all interpreters or bilinguals, and they had to interpret for a simulated interview, but their interpretation was actually authentic. So what we found was that on 7 separate accuracy measures, as you can see there, the trained interpreters outperformed significantly the bilinguals, even though the language competence, the level of bilingualism of the bilinguals as compared to the interpreters was not significantly different. So this proves that being bilingual is not enough to be a competent interpreter. So you can see the different aspects, different criteria that we looked at. Obviously, propositional content being the main one, but all of these other issues that are so important for legal interpreters. So what were the main differences that we found? The trained interpreters introduced themselves and their role. They interpreted directly using the first and second person. They explained their obligation to interpret everything. They asked the speakers to avoid any overlapping speech so they could interpret everything, whereas the untrained interpreters didn't introduce themselves or their role at all. The trained interpreters managed difficult situations such as aggression or swearing or overlapping speech by doing different things, having different strategies, switching to simultaneous interpreting, reinforcing the role when needed so that they could do ethical performance, and asking speakers to stop and allow them to interpret. Whereas the untrained interpreters simply omitted difficult content. So there was a lot of omission in their renditions. So question 2, does interpreter location make a difference? So for this project, we had 103 qualified interpreters in Arabic, Mandarin, and Spanish, and you can see who the researchers were. This was funded by the FBI, and we've got an article forthcoming there that you can read in detail if you're interested later. So what we found was that as you can see, the white is the performance of interpreters in person, the pink is via video, so audio video, and the red is audio only, simulating telephone interpreting. And you can see the trend that interpreters performed better always in person, followed by audio video and audio visual, and followed by audio only. When we combined the different aspects, so we were divided in interpreting accuracy, so all of the different aspects of accuracy, and we compared those three, we found significant differences between these two, which were the in-person and audio-visual, with the audio only. So there were no significant differences between the in-person and audio-visual, but there was significant differences with the audio. So the same thing with the management and coordination skills. So this shows very significant differences where visuals are so important and where telephone interpreting or audio only interpreting should only be the last resort for emergencies only. But for everything else, if the interpreter cannot be present, it is comforting to see that there are no statistically significant differences if an interpreter is able to do the interpreting via audio-visual remote interpreting. The third question is, does the mode of interpreting make a difference? And this was a different type of research study where we looked at the jurors' evaluations of credibility of the accused, who was a Spanish speaker, through an interpreter who was also an actor. So here we didn't want to include the variability of different interpreters. So we had a model interpretation repeated many, many times for the benefit of 449 jurors who assessed the credibility. And some of them heard the interpretation by the interpreter in a consecutive mode where they could see the interpreter, as you can see in the picture. And some of them heard the interpretation when the interpreter was in a booth to the side. They were looking at the accused, but listening to the interpreter interpreting simultaneously. And you can read the article there. This was funded by the ARC. And what we found was that the consecutive interpreting tended to distract jurors more than simultaneous interpreting, and they tended to get some of the case facts wrong afterwards, whereas with simultaneous interpreting, they tended to follow the case a lot better. There were significant differences between the monolingual condition and the consecutive interpreting condition for juror perceptions of the accused, with the latter eliciting more positive perceptions of the accused. So we found that when the jury were able to concentrate on the interpreter because they could see the interpreter rather than on the accused, they perceived the accused more favorably. And we speculate that that's because they were actually assessing the interpreter rather than the accused. Whereas when they were not able to see the interpreter was simultaneously interpreting, they heard the interpreter, but they were paying attention to the accused, then their evaluations of credibility did not differ from our monolingual control group. So there was no significant difference in the evaluation of the credibility of the accused between the monolingual control and the simultaneous interpretation, but there was a difference with the consecutive. So that leads us to the conclusion that simultaneous interpreting without seeing the interpreter is a much better option if we want to remove that interference of the interpreter. So to make it as close as possible to a monolingual situation. But having said this, there were no significant differences at all between the monolingual condition and the simultaneous mode for juror perceptions of the accused, and no significant differences in the conviction rates between the monolingual and the bilingual interpreted cases. So For conviction, it didn't make a difference. The question that remained after this study was whether we can recommend simultaneous over consecutive, because we didn't know if interpreters were able to perform equally well in both modes. So are interpreters able to be as accurate when they interpret in the simultaneous mode as when they interpret with the consecutive mode? So that was the next question for other research, and this is a current research also funded by the ARC Discovery Grant, and the preliminary results that we're finding also in 51 qualified interpreters in Mandarin and Spanish is that we have found no statistically significant differences in the performance of these qualified interpreters, they're all qualified interpreters, between the consecutive and the simultaneous modes. So what we can conclude is that if interpreters are qualified, they're trained in both modes, then they are able to competently interpret equally well in both modes, which means that the simultaneous mode is a better option for the other reasons that I've outlined from previous research. And we found exactly the same with consecutive versus simultaneous modes in police interpreting, with 70 qualified interpreters in 3 languages, Arabic, Mandarin, and Spanish, where we found no significant differences in performance between the consecutive and the simultaneous modes. So once again, that has answered that question that we had that was due to the previous results. So we can see here that slightly better performances in the simultaneous modes for all of the criteria, but no statistically significant differences. So that is a good result. The next question was, do briefing and preparation make a difference? And these are the results of our PhD student. Ludmilla and I co-supervised this PhD student, and it's the publication is about to come out, where she compared the performance of students between themselves, those who received briefing and those who didn't receive briefing, and the difference was significantly different. And similarly with practitioners, with professionals, again, those who received the briefing were significantly better in their performance to those who did not receive any briefing at all. So this once again proves empirically that interpreters are not just asking for briefing because they feel like it or because it's a whim, but we can show empirically that the performance improves once they are briefed. So the next question was, can equipment make a difference? And we haven't come up with empirical results for this, but we have anecdotal evidence so far that says yes, that the equipment can definitely help, and that working in pairs is something that can also help due to the reduction of fatigue. So what are the evidence-based conclusions? And this is important that we talk about evidence-based conclusions rather than anecdotal evidence or people's wishes or preferences or desires. So number one, that trained interpreters perform significantly better than untrained bilinguals. So trained, qualified interpreters should always be given preference when work is offered to interpreters. And the second answer, that audiovisual remote interpreting is as effective as face-to-face interpreting, proves that it is much better to have the best qualified interpreter interpreting remotely via audiovisual than to settle for a less qualified interpreter face-to-face. So these two things go together. And currently the recruitment practices of the LSPs don't quite allow to give preference, I don't think, to the best qualified. They only look at NAATI certification, but not every NAATI certified interpreter yet has received adequate training, and this is improving with the changes that NAATI has introduced. The third conclusion is that there was no significant differences in performance between the two modes of interpreting, simultaneous and consecutive. And if that is the case, then simultaneous interpreting seems to be the better mode for a number of different reasons. Briefing, interpreters perform better when they are briefed and when they are prepared. And equipment and working conditions, that better working conditions are conducive to higher quality for a number of different reasons. So I'll stop here. I think I stuck to my 10 minutes, and I leave some time for the Q&A session before I go to the conclusion. Thank you.
Thank you very much, Sandra. That both contextualizes what we have been discussing and provides evidence. And it's almost a conclusion in itself, isn't it? So I am aware that we are going past the time. So those of you who need to leave, please feel free. I would like now to invite our colleague and co-investigator, Professor Melanie Schwartz, to open the floor for Q&A. There has been quite an active discussion in chat, and I think some of the questions may have been already answered. But if you have any additional questions to any of the presenters, please go ahead and start writing your questions in chat. Mel, are you there? And can you
I'm
take?
Here. I'm ready.
Hello.
It has been just the most incredible experience monitoring this chat. It is a real testament to the robustness of this community of people involved in this subject matter. There's been like almost this kind of side symposium going on in the chat. So much of the discussion, sort of people have been answering each other's questions, but there are a few who were, that was to particular speakers. So if it's okay, I might just, there's only about 3 or 4 of them, so we might sort of have 10 minutes or so. So I'm going to put them to particular people, and if you're okay to keep your answers short, then that will be great, and we'll try and get everybody out of here as close to 1:15-ish as we can. So Ludmilla, the first question is for you. It's from Juliet Scott, who asks whether you have seen any weaponization of interpreters by lawyers, which she has experienced in US proceedings. So, and by that, she refers to the use of using interpreters to further the lawyer's case, even raising a question as to the accuracy of interpreting simply to disrupt proceedings and to turn that to their advantage. And there was another comment in the chat from Georgia Papagiannopoulos, who also referenced barristers who try to trip up the witness by using convoluted language. And if they don't get the answer that they want, they lay the blame onto the interpreter. Do you have any comment about that?
Yeah, look, on the basis of the observations that I have conducted, I would say no. I haven't seen interpreters trying to use, I haven't seen any instances of lawyers using interpreters strategically to undermine the other party's case or to destabilize a witness. And in fact, I would give credit to judicial officers who very quickly intercept, and I've seen that, who intercept that kind of actions on the lawyer's part. So a brief answer is a no. I have not witnessed that in an Australian court.
Thank you very much. Judge, there's a question for you if you're happy to take it, Judge Banton, which is about the the opportunity that you give, or the direction that you give interpreters, that if they want to raise anything that they to be proactive about any difficulty that they're having or any difficulty that they're finding. And I'm wondering whether you find that the interpreters take up that direction, and whether you have kind of quite an active experience of interpreters in the courtroom when they're given that opportunity?
Yes, it is something I routinely do, and I have it in my checklist as part of, because it is comprised in the documents as part of the interpreter's duties. I haven't had any difficulty with interpreters not raising it, and yes, people have tended to be. I don't know whether that's because I've signalled that they should, and so people feel more comfortable raising, for example, a cross-cultural communication difficulty or a misunderstanding. But yes, it happens quite often. Interpreters do seem to feel free to raise it.
Thank you. There is a question from Tong Chen who says that they've been on a multicultural New South Wales panel and finds that there's no channel for feedback either from court to interpreter or from interpreter to court. And briefing is, as we've heard a lot about tonight, one of the many issues that interpreters are facing daily. Is there discussion of any platform to allow feedback, either a simple survey or a more detailed feedback when necessary? I'm not sure who would be best to take that that question. Who would like to take it?
Mel, maybe I should, because I'm on the JCCD subcommittee. As you know, or maybe not, but the RNS does have a recommendation for such a platform, and we have been talking about it during the revision of the RNS, and we are in the process of coming up with some suggestions as to how to have such a platform or such a process. So, we'll keep you posted.
Thank you. Judge, there's another question for you about what you do when you suspect that the interpreter is not up to the job.
If I have a concern that the interpreter is not interpreting everything, for example, there's a lot of speaking and no interpreting for passages of time, or the interpreter speaks directly to the witness without first, or does something which is unexpected, I will always intervene and just confirm what the rules are and check whether there's a difficulty. It might be a misunderstanding, but we have to be pretty proactive in intervening. Fortunately, that doesn't happen very often. And I endorse, coming back to that earlier question to Ludmila, I haven't had experience of lawyers weaponising the process. I mean, occasionally an issue will arise about whether there's an inaccuracy in the interpretation, but I think the Australian experience of legal practitioners in court process is reasonably different from the American experience.
Mel, can I just follow up as what Judge Fanton said, as well as what the original question had? What I found from observations and from the interviews with judicial officers is that any comments or any objections to the interpreter and interpretation usually addresses the interpreter's conduct rather than their inability to interpret. And clearly a judicial officer is not in a position to assess the accuracy of interpretation. But there are very limited reports about issues raised about the question of accuracy of the interpretation. There were issues raised about omissions, and I mentioned before very short answers given when the original statement was significantly longer, but very little came up in terms of evaluating the actual quality of interpretation. actually, I do remember that there were comments about interpreters who ask for repetition consistently, too frequently. So that was one of the comments about interpretation quality being challenged. Yeah, sorry for that intervention.
Oh, thank you. Well, I think that there's one further question, and Heather, I think this is going to get us where we need to go in terms of your question as well, but let me know if it doesn't. There is a question about asking whether people can comment on situations in which an issue might be raised with a judicial officer about engagement or competence of interpreters, to which the response might be, well, that's a problem for the department, and then raising the same issue with the department and getting the response, that's a matter for the judiciary. And I think the way that Heather put it was, what is the authority of judicial officers in the face of a refusal for, to give the appropriate resourcing or access for interpreters? Again, I'm not sure who'd like to take that question. Who's interested in that one? Well, maybe it's a question about whether anybody has observed that type of, whether that's something that people commonly observe, that there's a kind of a buck passing between the courts and departments about whose job it is to ensure that the things that need to happen do happen. Is that something that people have commonly experienced or observed?
Can I just comment in what regard? So is it what are we exactly talking about? Is it about briefing, background material? Is it about? Yeah, fair question. There wasn't anything specific in the question as it was asked. Maybe whoever's so interpreter competence and appropriateness for the job. So I think then it's, Heather, if I'm understanding properly, it's more about a complaint, where there's a complaints process. So if there's a complaint against an interpreter, then as a language service provider, and we would have to follow a complaints management process. Now, the interpreter or translator has also the right to make a complaint to us about officers or certain staff or services that they were out, whether they were either, disrespected, mistreated, or just, whatever the nature of that complaint. So they also have the right to make a complaint to us, and we need to follow that complaint management process. Okay, thank you.
Mel, I'm afraid we have to wrap up. We're already 15 minutes late. Sandra, did you want to to sum up in very, very briefly?
Okay, so very briefly, thank you very much. Thank you, everybody, for all your comments, all your interest in the chat. I think rather than summarize what we've all heard, which has been so much, I think one thing I'd like to say is please don't lose hope. I started working on this 30 years ago or so, and it was very, very different. And I've seen the changes, the improvements. I've been training judicial officers for over 20 years. I have observed judicial officers who do wonderful things in court. The problem is that obviously not everybody gets those wonderful judicial officers. I've also seen many good interpreters, many good LSPs doing the best they can to improve the situation. We need to do a lot more, but we have to all take responsibility, all do what we need to do to educate each other, to implement what we know we need to implement in order to provide a better service for the benefit of everybody involved. It's not just for the benefit of the interpreter. In fact, the interpreter doesn't benefit much at all except for self-esteem and knowing that they've done a good job. It's for the benefit of justice. It's for the benefit of the courts, of everybody who works in the courts, and obviously for those who don't speak the language of the court. But I would encourage everyone to speak up, and for interpreters to ask for what you need in order to do your job properly. Discuss with the judicial officers, discuss with the lawyers, with everybody involved. And if you don't speak up, nobody will know. Very few people will be versed with what you need. So it's the interpreter's responsibility first and foremost, I think, to ask for what you need. And then if you are rejected and denied what you need, then you can take the further step, like going through the LSB, so they can speak on your behalf and so on. But I think we have reached a very high level, not only in the knowledge of the academy, the research that's been done. We've got evidence base to back up our claims, and we have a lot of people who are helping, and we have a lot of allies from the judiciary. And as I said, when I started 30 years ago, I was one of the few, with Miller and a few others who were working on this, and very few judicial officers knew anything about interpreting. And now we've got a whole team of judicial officers working to help this happen. And the JCCD is a great body, a great committee of people there, committed judicial officers who are helping. So, I think everybody should take responsibility and be optimistic that things will improve. Thank you.
Well, Sandra, thank you for a very encouraging and very inspiring conclusion. I think that's what we all need to hear. So thank you, all the presenters, Sandra, Stephen, Rima, Judge Fanton. Thank you for your active involvement and participation. Mel, thank you for moderating our Q&A, very complex. And thank you, everyone, our audience, for your interest, involvement, your passion. And let's hope for the better. We hope to see you all next year at next year's symposium, if not before. All the best. Have a good end of the year. Let's hope that next year, no matter whether we meet in person or remotely, is going to be a better one, an easier one. All the best to you all. Bye-bye.
Thank you.
Bye-bye. Bye.